Let me start this video with a question that might sound obvious, but is actually the foundation of everything in fundamental rights. You know that fundamental rights protect you from the state. But what exactly counts as the state? Is the local panchayat a state? Obviously, yes. Is the army a state? Yes. What about a public sector company like the Oil and Natural Gas Corporation? What about a central university? What about a cricket board like the Board of Control for Cricket in India? This is what Article 12 answers. And why it matters is this. If something is not a state under Article 12, you cannot enforce your fundamental rights against it. If something is a state, it is bound by Part 3. So Article 12 is literally the gateway to your rights. Get it wrong, and your rights become unenforceable against powerful entities. Article 12 defines state as including the government and parliament of India, the government and legislature of each state, all local or other authorities within the territory of India, and all local or other authorities under the control of the government of India. The first two parts are easy. Central government, parliament, state governments, state legislatures, all clearly the state. The third part, local or other authorities, is where all the litigation happens. What does other authorities mean? Can a government-owned company be a state? What about a university funded by the center? What about an autonomous body set up by the government? The Supreme Court answered this progressively through a series of cases. In the Rajasthan Electricity Board versus Mohan Lal case of 1967, the court held that statutory bodies created by legislation, like the Electricity Board, are the state. The test was simple. If Parliament or a state legislature created you through a statute, you are the state. Then in the Sukhdev Singh versus Bagatram case of 1975, the court held that major corporations like the Oil and Natural Gas Corporation, Life Insurance Corporation of India, and Industrial Finance Corporation of India are also the state even though they are companies, because they perform public functions and are under deep government control. But the most important and most tested case is the Ajay Haja versus Khalid Mujib case from 1981. Justice Bhagwati in this case laid down 6 criteria, known as the Ajay Haja test, for determining whether a body is a state under Article 12. The 6 criteria are: 1. The entire share capital of the entity is held by the government. 2. The entity enjoys monopoly status conferred by the government. 3. The functions it performs are of public importance and are governmental in nature. 4. The government exercises deep and pervasive financial control. 5. The entity is a transfer of a government department. 6. It functions similarly to a government department. If a body satisfies a majority of these criteria, it is a state under Article 12. Now the most famous exam question on this topic. Is the Board of Control for Cricket in India a state under Article 12? The answer is no. The Supreme Court in the Zee Telefilms Limited versus Union of India case of 2005 held that BCCI is not a state under Article 12. Even though BCCI controls cricket throughout the country and has a kind of monopoly over the sport, it is not a statutory body, it is not funded by the government in a pervasive way, and the government does not exercise deep pervasive control over its functioning. The key principle that comes out of this is that mere regulation of a public activity does not make a body the state. Control must be deep, pervasive, and structural. What this means practically is that if a private hospital denies you emergency treatment and violates your right to life under Article 21, you technically cannot file an Article 32 petition against that private hospital because it is not the state under Article 12. This gap is becoming increasingly serious as more public services are privatized. For your exams, remember these 3 things. ONGC, LIC, IFC equals state. BCCI does not equal state. The test is the Ajay Haja Deep and Pervasive Control Test. Now your MCQ. Which of the following is not considered a state under Article 12 of the Constitution? Option 1. A university established by an Act of Parliament. Option 2. The Oil and Natural Gas Corporation of India. Option 3. The Board of Control for Cricket in India. Option 4. The Rajasthan State Electricity Board. Think carefully. The correct answer is Option 3. The Supreme Court in Zee Telefilms 2005 held that BCCI is not a state under Article 12 because it is not a statutory body. Government does not exercise deep pervasive control over it, and it is essentially a private body despite having a national role. Options 1, 2, and 4 are all state because they are either created by statute or satisfy the Ajay-Haja deep and pervasive control criteria.